Good afternoon. Welcome at this panel on data transfers. Data transfers on the ground we're going to talk about, a fascinating subject. I'm happy to see so many people here. It's Friday afternoon after lunch and still so many people here. So that seems to be a good start for hopefully a nice panel. My name is Hielke Heijmans. I'm the chair of the litigation chamber of the Belgian authority. I'm a member of the Belgian Data Protection Authority, and I also teach at the VUB in Brussels here as well. I have with me a great panel, starting with Finn from Norway, Finn Mierstad, who takes the subject from a consumer perspective. Then we have the European Commission here, as should be, Estelle Massé, someone who works in the area for a long time, also outside the Commission, so she can give different perspectives, I think, to what we work at. Then there is...
Should be closer to the microphone, sorry.
Yeah.
There.
Then there is Jacques Mandrion from Salesforce and Theodora Lalova-Spinks from Ghent University. Jacques will talk more from the industry perspective, and Theodora will discuss more the issues in the health sector, where she has a lot of views on. What are the issues at stake and what are we talking about? Data transfers, we discuss this a lot, especially in these kinds of panels. The half of them sometimes are about data transfers. Now it's also AI, but it was also a lot of talking about data transfer and transfer mechanisms. What we try to do in this panel, I hope people hear what I say. What we try to do in this panel, in any case, is to look at reality, not only at the law, but also at reality. We try to find out whether or not these difficult principles we've put in the law, Article 44 until 49 of the GDPR, and then besides that, all the case law there is on these articles, as well as the EDPB guidance in several instances, if that reflects reality. I think that's the main question which I would like to bring about. People told me sometimes that after the privacy shield fell, that basically in practice nothing happens. If that's true, I hope it's not true, but people told me so. So those are things we would like to discuss here. What is the real problem about data transfers? Of course, we are in a quite complicated geopolitical situation where things are moving. The big question maybe, or maybe not, maybe that legal certainty, the lack of legal certainty, might be the biggest problem we face with at the moment, at least where the practitioners face with. The other question is whether or not our strict transfer rules, and that's the thing mainly Theodora will enlighten us about, whether the strict sanction rules, whether they hamper innovation and also good solutions, for instance, in healthcare. Global standards, are those the options? And more in general, what new solutions can we have and what we want? But the main question remains reality, the reality check of all this, of this very complicated system of data protection, of data transfer rules. Of course, we are here at the Legal Scholars Symposium at the CPDP, and I think it's also good to hear a bit about the law, how it is. I'm curious what Estelle wants to share with us, hopefully not only about the law, but also about the practice. From the Ivory Tower in Brussels here.
Thank you. Thank you very much for having me and for bringing this topic forward. It's true, I think, for the time that I've been attending CPDP, there was always discussion on data transfer. However, we intend to go deeply into either specific mechanisms or a specific transfer tool, but rarely to go back of why exactly are we doing what we're doing? Why are we talking about developing transfer tool? How does it fit within the EU approach to data protection, but the right to data protection also in general? So I'll start with taking this step back, which of course links to the law, but also very much links to the practice and the reason why the GDPR is the way it is in transfer. Yeah. Okay. Is that better? All right. 2 of them, okay. All right. So going into the starting point of what is being considered or what is being looked to, what is the objective when we are talking and developing data transfer in the EU. As it's found its ground, like the GDPR, in the need and the obligation to protect the fundamental right to data protection, also closely linked to the fundamental right to privacy. The ultimate goal and the guiding principle is to ensure that the protection that individuals are being afforded to travel with the data. It's something that you would have heard a lot of time, and it's something that is at the core of the instrument that we're designed and put through in the legislation. And then comes the point of putting them in practice, that it also, the second guiding principle is ensuring that those mechanisms and those tools bring legal certainty for operators that are using them while protecting the individuals. You have on this panel actually different sides of what we mean by operators. It's often that, a lot of large companies are being thought through as the prime user of data transfer, but actually data transfer is a necessary tool for researchers, for businesses to operate their own administration, for artists to exchange, for a humanitarian NGO to be able to protect the one that they are serving, and so on and so forth. And that's why those main 2 guiding principles is what you will find through all of the different tools that you have in EU law. So I'm not going to spend a lot of time discussing the different ones that are available. I think everyone here sort of knows them really well. But they all have similar component, because the point is also to make sure that no matter which tool is used for transfer, from adequacy or standard contractor clause or BCR, is that they have binding and enforceable safeguards for the individual, that there is a clear right to redress, and there is this level of protection that is maintained. Now, of course, throughout the years, those systems have been developed, have been improved, have been clarified by amendments to the legislation from the 1995 directive to the GDPR, and also through, of course, guidance from the Court of Justice in clarifying key aspects of what needs to be considered when a transfer happens. All of this has brought us to where we are now, and continue developing those tools. Increasingly, you would have seen that as the EU was upgrading its model, it also happened around the world. A lot of countries have also adopted privacy and data protection legislation that bears a lot of similarities with the EU approach, leading to what we call the convergence model, and giving the opportunity to develop those tools and enable those safe transfer, ensuring that when data move from one place to another, a level of protection will be maintained. And so in a context where indeed we are facing challenging times, a lot of shift, there are still fundamental points that are here and not changing. The fact that privacy is a universally recognized fundamental right, that we are living in a scenario where today more than ever, where we have more privacy law and data protection law around the world than ever, opening the opportunities for more transfer tools to be developed in a really robust manner, is something also to not lose sight of, despite obviously acknowledging the challenges that we have with continue perfecting the system and ensuring that it works for all parties involved in it. And so on the basis of this increased convergence, I also want to touch upon on the ground something that the feedback we have received from different actors, being from the consumer side, but also the business operations side, is also the need to make our tool work with each other when they're similar. So you will have seen that there is a focus on developing and trying to advance what we call mutual adequacy decisions. So not just going one side, but acknowledging the multi-side of those transfers. This is part of the work we're in negotiation, for instance, with countries like Brazil at the moment, or also exploring how other tools, like the contracts that we have when other jurisdictions adopt very similar one, how to make them work together so that business entity don't have to rely on so many different ones, but that we would acknowledge that, okay, the EU contract rules are similar to the one of the Council of Europe, for instance. So if a country were to adopt these ones, like, could they potentially use them? It's not something that exists right now, but it's something that is being put as part of reflection of also further acknowledging that I think fundamentally what has been changing in the past few years is the acknowledgement that on the ground, transfer is not a bilateral issue. It's not a one place to another. It's a multi-layer framework, and we have to think of how to use our tools that are being designed for a very good reason for the guiding principle that I mentioned before by our legislature, to make sure that they fit this reality of the multi-layers while keeping the high level of protection. Now, I know that developing those tools is slow, and it takes time to do those things, but it takes time to make sure that the tools remain credible, useful, and they last. And obviously, we've learned with time also, with the clarification that's been brought on what to do and how to further develop them. And you would have seen, I think, there were quite some moments at CPDP when we were discussing, also way back when, the length of the ruling of the Court of Justice, like how much they evolve and how much detail they are now, and still we're still discussing what exactly it means, et cetera, et cetera. If you look at, for instance, the length of initial adequacy decision under the 95 directive and the length of the ones that we have now, of the monitored one, they're much more developed. They go into much more detail because also our frameworks have been clarified in so many aspects and requires to look in many components. It may look long and it may look tedious and we get calls to move faster, but it's also important to know that, okay, once they're in place, they can be used immediately and it assimilate a country to our single market. So the gains are huge, meaning that the responsibility to get it right is also huge. Obviously, we know that it's always a developing road and there will be always development to make the tools stronger, but for us, always coming back to this point, making sure that the two guiding principles are fine there, no matter the tool use, is the key. And I will end with just the last point. For us also, the development that we see on our framework and what we take into account is obviously what stakeholders brought us, and sometimes the way to do that is also seeing where the enforcement is going. So the importance of the enforcement, like any aspect of data protection law, is key, and seeing where cases are being brought and which aspects are requiring more clarification is always an indication also of where more development could happen. So I'll leave with that, and I look forward also to hear from fellow panelists on their experience on the ground. Thank you.
Thank you very much. I know that the Commission indeed engages a lot with stakeholders. So let me now move really to the ground and to the real stakeholders, starting with the consumer perspective. Finn, please.
Thank you. Thank you. And thank you for inviting me to this panel. Hello, everyone. It's fantastic to see so many people here. So my intervention here will be mostly in my role as chair of something called the Transatlantic Consumer Dialogue. As abbreviation is TACD. It's a network of about 75 groups in Europe and in the US. And I co-chair the digital work of this network. And I've been working in this field for 12, 13 years almost. And when I started, I remember hearing about something called safe harbor. And and I was told, I was new in my job, I actually came straight from Brussels, working on the energy field, and I was new to the digital field, and I was sort of told, don't worry, everything is okay. We have something called safe harbor. And then I started working in my day job, which is at the Norwegian Consumer Council. We do investigations, we read these terms and conditions that we all click yes to, right? And we don't read them anymore, because if we did, we would not have a life. And we also started working with computer scientists, and we hacked all the apps. We looked at the data flows. We worked with many experts who are here today. We've been inspired by the work of many here and people who participate at CPDP. And we just discovered, there was no protections. And that I'm not going to do a big blame game. This was, data completely out of control, being shared to thousands of companies in real time. It's still happening. Consumers have no protections in practice when it comes to these practices. And I would argue that, therefore, if we're going to start sort of a blame game, I would blame everyone, really. I won't blame the US for lacking a federal privacy law, but that is a real problem. Our US members are asking for this. If you ask them what would you like first, they want a privacy law first, then probably regulation on AI. But the lack of a strong federal privacy law, in our view, makes transfers to the US unsafe. And we've been arguing this ever since the Snowden revelations, but Schrems, of course, dealt with the government surveillance part in Schrems decisions, but no one really cared about the consumer part, because there's no real access to redress. There's huge lack of transparency. Complaint mechanisms don't work. It's a self-certified system, and even though there's been improvements in other iterations of the safe harbor, it still doesn't really make the cut from a consumer perspective. So we try, when we talk about these things, it's really, from our point of view, this is, really, this is what's happening. So it's not working. And also in Europe, Europe is to blame. We didn't enforce. Even when we had the predecessor to GDPR, there were some really good articles in that, but we didn't enforce it. And I wouldn't blame it on the data protection authorities. They weren't designed to do this job because the politicians didn't fund them and equip them with the tools they needed to do their job, right? So this is also a highly political issue. And I think that's still the problem today. So we're going to talk about the solutions, and obviously that is a big question. And I don't have all the answers. I'm not a lawyer, and I really respect the job that Estelle is doing at the Commission, and the Commission is trying to balance so many different perspectives and needs, and it's also, of course, affected by the politics. And of course, then we cannot ignore what's been happening in the US since the last election. Our US members are now knee-deep in lawsuits trying to save what's left of consumer protection. A good friend of mine, Rohit Chopra, was fired from the Consumer Financial Protection Bureau. Right? They're trying to close down one of the few privacy regulators you have at the federal level. The two other Democratic commissioners at the Federal Trade Commission were illegally fired. Right? So there's no adequate protection in the US. There never was. But there's definitely not now. And so I'm not saying we should shut down data transfers today to the US, because we're all super dependent on these services. So what do? I do think we need much stronger enforcement, and we can probably talk much more. I mean, that's not only on data protection, but on competition, the Digital Services Act. We need to use public policy to create alternatives. The same way we've done in the renewable field, which is a field I know well from my previous job, we created incentives for renewable energy. And we're doing quite well in adopting renewable energy in Europe today. Some people argue we are too slow, but definitely without incentives from the public sector at the European level and at national level, we would not have had the amount of adoption of renewables that we have today. And we could say the same thing about technology. If we think that these major services that we're using today are not in line with our values and not in line with our laws, and also now being, of course, much more prone to political meddling, which we have already seen. The news story that broke last week with a certain company blocking the email of a certain judge in the ICC is a good example of that. The way Meta fired their moderators and stopped fact-checking as a direct result of political interference, or not even interference, but aiming to please political interests. We're seeing now this tech is not neutral, and there's a huge risk for us, both from the consumer field, but of course also in other aspects. So we need to use public policies to create alternatives, and we need to use the wide range of digital enforcement tools to create interoperability, data portability, and this is not going to happen overnight, but we need to start having that conversation. And I know this conversation is happening already in Brussels, and then my only encouragement then is that we don't copy the business model in the commercial field, which is based on commercial surveillance, collecting as much data as possible, but on other values and stake out another direction, which is both good for the consumer, but I think also the issue that's been mentioned in many panels here about digital sovereignty. And it's not about excluding US companies, but it's bringing a better level of protection for both US and European consumers, which I think is possible. So that's the big picture from my end. Thank you.
Thank you very much, Finn. The discussion is already there because Estelle told us that the protection travels with the data. Then we have Finn who tells us basically protection does not travel with the data. So now I'm curious to hear more in detail from you. Also in terms of solutions, I think the idea of digital sovereignty is of course extremely important. In any case, go ahead, Jacques.
Thank you. Hi everyone. Can you hear me properly? Yeah? Okay. I'm very happy to be here, very happy to be able to talk about this subject on data transfers. I'm part of Salesforce, which is a cloud provider, so I'm going to represent the interest of the industry. I'll also be able to be the voice of the customer I'm exchanging with daily, so EU companies. And the notion of data transfer is always a recurrent subject. We have a lot of talk about that. Sometimes we have questions like, why do we really need transfer of data outside of Europe? Is it something we should advocate for? Should we try to block them? Well, the question for me will be like, is it possible actually not to have any transfer of data outside of Europe today? I think it could be technically be done, but it will come at a cost, so that will depend on the objective of the stakeholders. Vince was speaking about sovereignty. When you look at this term, this strictest definition of sovereignty is complete autonomy within a country or a region. That means you have total independence and control on everything's happening in that region, from the supply chain, the operation, to the technology involved. Today, in our global economy, interconnected world, it will be difficult to implement such sovereignty at the European level. It will be very expensive. It will cost a lot of money, but also a lot of resource and time. But also, it will come as a cost for an impact on the performance, on the innovation, and on the competitivity that EU organization, but also EU individuals wants to benefit from. So we think prohibiting transfer outside of Europe will not work nowadays, but we totally understand that there is, and also I forgot to mention, like, many EU companies operate globally actually. So they also export their goods or their service outside of Europe. They have affiliates, employees outside of Europe. So there is this global economy also apply to us. But yeah, right now we are seeing with what's happening when a new economy, a big country wants to be super protective and change the face of the economy and the international relationship, that creates massive tremors and fears. So in this time of geopolitical tension and under this level of scrutiny that we have from regulators, it totally makes sense for EU countries, EU citizens, EU organizations to demand for a higher level of digital protection. One that will bring operational resilience, but also protects from unauthorized access to data. At Salesforce, we believe that this is doable. You don't have to prohibit data transfers, but you just have to protect the data better. There is all the transfer mechanism, the legal protection that Estelle talked about, that are still valid nowadays, that we should rely on. They have not been, even if there is an uncertainty around a potential Schrems 3 case, yeah, maybe it's going to happen, but we have several transfer mechanisms in place. At Salesforce, we always advocate to implement as many multiple transfer mechanisms in your agreement. So in case one is invalidated, like it was the case a couple of years ago, like it might be the case for one of them in the future, at least you have fallback. So in our agreements, we have the 3 transfer mechanisms in place. In addition, with the legal protection, you can also ask your providers, the company you're doing business with, to offer data residency and support in the EU, so that your data are localized and the processing operation are also localized in the EU, so that you are under EU jurisdiction law. But that could also come at a price. Usually the services are more expensive when they are done only in the EU. The third aspect is also, and one of the most important, I think, is the technical safeguards, like encryption. Encryption will be probably the key to many, many things. Interesting to note that in Europe, we look at the risk from unauthorized access from foreign authorities as under a privacy lens, because we have privacy rights, and as Finn was saying, in the US, they don't have a federal privacy law, so they are not protected. But in this type of other jurisdiction where there is no privacy right, they will see foreign access to their data, like the US is afraid of China getting access to their data, as a security concern. So encryption, security tools could be also a way to protect the data and to secure data transfers. Another part that is important is that to maintain in control of your data. Companies are very aware and very careful about what is being done with their data, and that's great. We should always advocate for more transparency. It's good for companies, it's good for individuals to know what's happening to their data. And the last one is also look at who you're dealing with. Look at the regional investment, the regional partnership of the companies you're in business with. Is it just a company located abroad without any interest in the EU? Or is it a company, headquartered in a different country, but with a long history in the EU, massive investment in the EU, jobs and everything? Like at Salesforce, we have been in Europe for 25 years. We have more than 10,000 employees in Europe, offices in 12 countries. So that's indicators that company also wants to have a long-term partnership and are reliable. So instead of thinking about all the risk with the data transfers, I like to think about the mitigation measures, the solution we can find, because I think we need these transfers. We won't be able to switch them off, but we could secure them. And securing the transfers, that's good for everyone, that's good for the citizens in the end. So that's my part. Thank you.
Thank you very much. This was a good, interesting intervention. Theodora.
Let's see if it works. You can hear me well? Hello, everyone. Thank you very much for the opportunity to be on this panel, and I'm very excited to discuss with all of you. So, as a postdoctoral researcher at Ghent University and a lawyer, I'm going to be bringing the health researchers and the patient's perspective. So far in my career, I've been focusing and collaborating. I have had the honor to collaborate a lot with biomedical scientists, with patient representatives. So I'm going to be bringing this perspective and sketch a little bit the picture how it is currently looking for research. EU researchers collaborating with people abroad. I also had the opportunity 2 years ago to have a short research visit in the States at Stanford University. So there we had the opportunity to look into the problems, especially transatlantic transfers between EU and the States. So what is the most important when it comes to health research? Actually, it relies very, very much on the use of special categories of the personal data, data related to health, genetic data, and that what also is very unique is that, especially for rare diseases, for pandemics like the one that we just had with COVID-19, we cannot really do research without international collaborations and international networks. What is also very important, and Jack already mentioned the importance of encryption, pseudonymization. Of course, if we try to fully anonymize the data in health research, this doesn't always work, especially when it comes to genetic data, and also oftentimes the value of the data for the research purposes is lower if it is completely anonymized. So in most cases, we really need to work with personal data, even if it is pseudonymized. I'm going to briefly sketch first the view of researchers. What are their current challenges, worries when it comes to international transfers, and then very briefly the viewpoint of patients as I've observed it. When it comes to researchers, we can speak of two, let's say, big topics of issues. The legal uncertainty that Jirke already mentioned at the beginning when it comes to transfer mechanisms, and practically when it comes to actually applying the mechanisms in real life, in practice. So unless we have collaborations with one of the countries with adequacy decisions, 15 in total, we look into the other possible mechanisms. And I'm going to give some examples where we could have bumps, especially for public researchers. Something to be kept in mind, of course, we have large pharmaceutical companies, medical device developers, health technology developers, and so on. But public health researchers, academics, research universities, they're also very, very important for development, for research. And often they would be the ones that would face the most challenges and issues. Why? Quick example. If we don't have an adequacy decision, and instead we fall to the use of appropriate safeguards, like standard contractual clauses, as we know, since Schrems 2, there needs to be a transfer impact assessment, which some scholars would equal to a mini adequacy decision and assessment to be made. And this, for a small legal team in an academic institution, oftentimes would be quite hard to do. It would be quite okay for a large company, but not for the universities always. Another example, if we cannot rely on standard contractual clauses, would be, of course, to think of the derogations for special situations, like consent, public interest, and so on. But there to keep in mind, they're only for case-by-case transfers, non-repetitive, which in the case of a clinical trial, in the case of a long-term collaboration, like an observational study going for 20 years, it would not work. So for health researchers, that would be one of the biggest issues. Practically, as I mentioned, of course, on the one side, for academics, risk aversion, worry to be in breach of the law, even if actually there is no such risk, still this would be a possibility for companies, for academics with smaller resources to have good legal teams or large legal teams. And of course, this on the other hand would lead to less collaborations, stout collaborations, less innovation. Briefly on the patient perspective, again, something to keep in mind, patients are very much willing to participate in research and for their data to be used for research. And also to keep in mind, health research is not easily comparable to other fields, commercial use of data in social media, and so on. Because the whole framework around it, beyond data protection, the legal and ethical rules are very, very stringent and very specific. So it is a quite unique case and quite safe case of use of data. When it comes to the patient's needs, if we have, of course, less research, we're also going to be seeing, of course, less new treatments, novel treatments, reaching the patients. Another example would be, of course, AI development, which we're seeing really huge progress in the last years when it comes to AI tools in healthcare, algorithms, and so on. If they're not trained on sufficiently representative data, of course, there are going to be biases and issues with that. So here the transfers, the collaborations, the international collaborations are very, very crucial. And something to keep in mind when it comes to, of course, having the choice of whether the transfer should occur or not as a patient. Of course, the quick association when it comes to choice is consent. But there is a huge, something that I always like to remind when it comes to data protection as a fundamental right. It is not absolute. It is always balancing the rights of the individual interests, and the interests of society, including public interests and research. And as I showed with the derogations example issue, consent is only for case-to-case transfer. Of course, patients, we have the whole framework around data protection and transfer, safeguarding the rights of the patients. So oftentimes it's not about individual constant burden of consents and choices. It is about the whole framework to work and to ensure that we have the enforceable rights and protections. This is very briefly on my part, but I'm happy to further elaborate during the discussion on all the points.
Thank you very much. I would like to give one round within the panel and then definitely open up the discussion because a lot of points have been raised. The problem, I think, of this panel is that the problems are huge, the solutions are maybe less evident. What I want to come back to is my starting point was, is there really a big gap between what we try to regulate and what happens in practice? That was the starting point. And I heard a lot of elements of this, but maybe if you can reflect all just quickly on that question. The next step is, of course, the solutions, but let's start by the fact, is indeed what we are regulating, is that in line with what really happens? And the problems we saw already in this panel, do they illustrate that there is a big gap? Maybe or maybe not. I remember Chris Koener all these years explaining to us, the ones who are a bit longer in this area, they know that data protection, data transfer rules are just an illusion. He has written whole books, whole articles about it. So that came back to my mind. But let's not be so negative. Let's be positive. Maybe then I start with Estella. Do the same order.
Okay, let's try. Can you hear me okay? Yeah. I think there is a gap in the sense that it's still a developing area and there is a lot that needs to be done to ensure that the safeguards being put in place are enforced, and they are indeed many regions of the world with who to cooperate and with who to put in place those mechanisms. So the gaps in the sense of not covering as many regions as it could be in terms of privacy cooperation are here. The gaps in terms of demands are here. I do want to address the point on, we're talking about the different tools and how they may work or may not work. It's important to acknowledge that we're in an area of law where we have unique tools for transfer, which are designed actually to limit these gaps, which doesn't mean that it eliminates it completely, but it's extremely important. When the legislation on which we base ourselves was developed, there was a conscious decision to not put data as part of services to be traded, for instance, to have specific tools for it to move. And because those tools are designed and here made to ensure that there is no such gap, that they are enforceable for the consumers, that they give legal certainty and they give those safeguards. That's acknowledging the specific nature of data that's linked to a fundamental right, and it's an area of law that is really specific in this area, but it's also one that allows to ensure that from a get-go, we don't create that gap, for instance, with the consumer, with the individual, by giving it an access to it. Now, does it mean that there is nothing more to build or nothing more to clarify? Certainly not. I mean, again, I've been around this conference enough in my previous role and my current one to know how much work we have to do as the Commission to continue clarify and develop a strong data transfer tool, and continue also monitoring the one that exists and contributes to their enforcement. So I would say we have the right tools to avoid those gaps, and then we still have a lot of collective work to do to make sure that they don't materialize, and if and when they do, that they're also remedied.
Thank you very much. I give the floor to you, Finn. I know that you see that there's a huge gap, maybe real protection, but maybe you also have some ideas which you can share how to solve this.
Yeah, I'd be delighted to. I think it was probably quite clear in the beginning that I saw many gaps. And I also thought I'd just quickly respond to Salesforce point. And I think your point about encryption is really good. I think that's in maybe a lot of cases that would be a very, very good solution to at least ensure that rights are being respected in practice. But I think there's also a limitation to that approach, and maybe not in Salesforce case, because you're mostly a business-to-business company, and you have a different type of incentive for how you handle the data, and you're not in the business of selling data, as far as I know. So, but if you look at in the consumer world, where I do all my work, there is very little incentive to do these things. Especially, I used the ad tech example earlier, how data is being sold and traded every time we use our phones, visit a website, use an app. This happens thousands of times a day. Our data is going everywhere. And these companies have no incentive whatsoever to do the things you discussed. And even if they did, there's no way for us to know if they comply with the other principles of the GDPR, which are important too. Even if the data is encrypted, if you don't respect data minimization, data protection by design and default, all these other really important principles, and purpose limitation, you really see that even encrypted data can be misused in so many different ways. So, and then you combine this with what we see with, there was a discussion before lunch here today about competition and digital monopolies. I mean, we see that these things are linked, right? Data monopolies, we see creates power imbalances between companies, but also between consumers. So there are gaps that are related to the data field. Data is the fuel. So I think in terms of solutions, I think in Europe we need to maybe be bolder. I know that this probably goes against the talk of the town today, but we need to be bolder also in a regulation. There's a plan to have a Digital Fairness Act. I think that's really great, very important, because the DSA and the DMA only covers the large companies. You lack a safety net regulation. So I think the Digital Fairness Act, which is proposed, will be add to a layer of protection, which will also benefit, hopefully, also consumers outside Europe, because I also have the US perspective in mind. I think we also need to discuss attacking the business model of some of these companies more directly. And there's been a proposal for a while to ban what we call surveillance advertising. I think we need to go that way, because then I think we can also create a much better groundwork for having international data transfers. Because I think, I mean, I'm not an expert in the health field, and I'm not gonna, I think your points, Theodore, were excellent, and I think patients would like to share their data if it can help to improve their health or other people's health. The challenge today is that people don't trust sharing their data because there's so much illegitimate use of data, and that's often then the collateral damage are the legitimate uses, for example, within health. And if you do look at research studies done in Europe and the US, Pew Research in the US or European Commission studies in Europe, like, it's overwhelming support to protect people's data better. Overwhelming support. So I think we need to talk about banning the worst practices outright. And I would love to see also more clear bans on dark patterns and deceptive design, because these things undermine data protection and competition. And then, of course, looking into the alternatives where discussions around portability and interoperability are key in order to create a better digital field, which will also allow for legitimate international data transfers, which I completely agree. In a global economy, we need, we're dependent on, and I don't think we want to have like a fortress Europe of data, but we need to separate the different things in a good way, and we're not doing that well enough today.
Okay, thank you very much. What I take from this mainly is that if we do it better in Europe itself, then the transfer problems are less, at least. If we have strong protection here, then also the transfer is easier and more protective. Maybe that's not what you said, but that's what I take from it. Look from it. Jacques, reality and law.
Yeah, thank you. Working in a B2B company can make things a little easier for me than if I was working in a B2C, because all the concern that Finn's raised, that comes from individuals, and that's the type of discussion I'm going to have with our customers. So as a B2B company, you're regulated and you're audited by the national DPA, but all of your customers are also kind of regulators, because they're gonna ask you a lot of protection, they're gonna ask you a lot of questions that they may face, because they want to be able to be protected, and they want to be able to provide responses and transparency to their own end customer or consumers or individuals that are using their services. So from a B2B perspective, all the values of the EU, that's why we try to implement. We try to give control over the data. At Salesforce, we believe that our customers should always maintain ownership and control over their data. So we will not use their data to train our AI model unless they provide an authorization for that. We're going to share information. We're going to share transparency. We want to give them information so they have a better understanding of what's happening with their data. So I think control is very, very important. It comes also from the encryption measures, also a massive key. And all the concern from Finn, like the investigation or the practices, the selling the data and everything, I mean, that's good that we have these cases surfacing. So that's also the occasion to provide more safety, to provide more guardrails, to make sure that practices are getting better. In the B2B world, you have to be very effective on that, because as soon as there is a case, I'm going to have like dozens and hundreds of customers reaching out to us. Okay, what's your reaction when this case has been enforced? How can you convince me that I'm not at any risk with your services? So that means you need to be reactive, and you need to give all the protection you can give to your customers, because they have to face public media, they have to face their own customers. So that's super important. Thank you.
Thank you very much. Control. Before I turn to the audience, because I think it's important in this setting to really have time for questions, I will want to hear some more from you.
Thank you, Helke. So when it comes to the health research perspective, I'm going to make two points. First, what I have seen researchers themselves advocating from the practical side so far, and I'd be very curious also to discuss with the final panelists. I've seen, for instance, the European Academies of Sciences, the European Academies of Medicine, looking for tailored solutions for researchers. So either in the sense of more support, how do they understand and how they should apply the existing mechanisms, or even to consider, for instance, creating research-related special contractual clauses. So really a mechanism that is specifically targeting researchers. So that could be one way to address the practical gap or the worries or the uncertainties. Something else that perhaps could be a little bit more provocative, but I'm interested to put it on the place. We have seen 2 months ago the first data space being adopted in the EU, the health data space regulation, which it has two major objectives. On the one side, of course, to empower individuals, how their data is used in healthcare, to receive more easily, for instance, care abroad when they travel. But also the other big objective is to unlock more data to be used for purposes like research, policymaking, innovation, and so on. And one case that I've been curious and investigating is, could actually within the new system that the European Health Data Space is putting in place, we're going to be seeing new administrative bodies, public bodies, the health data access bodies, permitting access to data from different sources in each country. And there is a possibility for a third country to add a national contact points after quite heavy assessment, of course, from the Commission. And if there is transfers between the EU contact points and the third country contact points, of course, there would be subject to the transfer mechanisms under the GDPR. But could we find in this system a way to make it easier for researchers? I'm not going to go into the nitty-gritty legal technical details. I have some proposals on how this can be done, but perhaps that could also be something to put in practice and make it easier for researchers and use the new regulations that are now coming to the fore.
Thank you very much. The European Health Data Space, important as well. I would open the floor. Who wants to pose? I see a lot of questions. I start, I think, with Olala. And others are leaving. That was not the plan. There can be interesting questions. Let me start here with Ralf Bendaat.
Yeah, thanks, Hilke. A few remarks on what has been said. First of all, on the encryption debate, I think that's a smokescreen. If you transfer encrypted data, you cannot in any way process it further unless you decrypt it again. So it only secures the transport part of it, and we have a transport layer encryption everywhere on the internet nowadays anyway. So I don't think that solves anything, unless you really get to finally to homomorphic encryption and all that, but that's a different discussion. On what Estelle, but also Salesforce said, Jacques, maybe that was not intentional, but I heard some words like interoperable or multilateral. Estelle, you've referred to the fact that it would be useful to have a multilateral regime for data transfers and data protection. I'm always cautious about that because in Europe we are in a unique position that it is not negotiable. It's in the law, it's in the primary law, even in the charter and in the treaty. And therefore we made sure back in 2018, with the help of Estelle back then in the NGO community, to get these horizontal principles on trade agreements, that they cannot undermine our data protection rules. And the adequacy decisions are unilateral decisions by the Commission, by Estelle's unit, basically. So technically, they cannot be negotiated. They're unilateral. Of course, when Joe Biden and Ursula von der Leyen get a political agreement at a super high level because of the Ukraine war, you have to do something, I understand. But technically, the Commission could always withdraw their implementing acts. It's nothing more. And looking at what also Finn pointed out, what's going on in the US now, I wonder when that will happen. But then, Finn, also a remark, you said we should maybe think about a ban on surveillance advertising. I'm always cautious, because I was involved in the GDPR back in the day, working for the rapporteur. I'm always cautious to ask for bans of things that I think are already banned. Because the companies, they have tested it all the way down from legitimate interest to execution of a contract. They're now down to consent. It was tested at the Court of Justice. I would argue, even if you give your explicit consent maybe to surveillance advertising, it wouldn't be valid, because we also have Article 5 in the GDPR, which says data processing must be fair. And I can't see how that can ever be fair, and how you could even give informed consent to this. So I just wonder, because if you now start a discussion also with the new majorities in the European Parliament since last year and everything, and the whole deregulation agenda of Commissioner Verkunen and others, it's dangerous, I would say. Maybe the Digital Fairness Act can bring something, but be careful what you wish for. I would really ask why the data protection authorities, maybe also to Hilke, have not long ago sent the cavalry to these companies, and they're all well known. Wolfi Christel and others have done all the studies on the real-time bidding, quote-unquote, ecosystem. Just go there and shut them the fuck down. You know, I don't know why that's not happened so far.
I don't know exactly what your question was, but maybe we can ask some other questions. Your statements are clear. 1, 2, and then 3. Stuart.
I'm Stuart Dresner from Privacy Laws and Business Reports. My question is to do with this interoperability. The national authorities and the European Commission has been trying to work with the cross-border privacy rules, sort of US sponsored, of which it's not really working because the cross-border privacy rules have very few countries involved, very few accountability agents, and very few companies signed up to it. So it's like a straw man. That means it's something that's not really existing. So why is the European Commission and national authorities still trying to find a common way forward, a common legal framework to transfer data between the sort of safe EU, EEA area and the rest of the world, where in many countries the protections are very weak?
It's a very fundamental question. I still want to ask you had a question, then I saw one in the back. Maybe
Christos
get your
Velasco.
name as well.
Yeah, Christos Velasco, associate professor at the German University. My question is very much with regards to international data transfers under the context of the GDPR. We know this adequacy decision mechanism has been, adopted since the EU Privacy Directive. And it has been somehow very slow. I mean, it has been written by a number of, academics, including myself. I mean, for instance, in the context of Latin America. I mean, the pace of these mechanisms have only just found place in 2 countries, like Argentina and Uruguay. And the rest of the Latin American countries, like for instance, Chile, that recently came up with a new data protection law, Mexico, well, now they just updated its framework. And some of those countries, obviously, they don't believe that this EU adequacy decision might actually solve most of the problems. And in fact, they are looking at Convention 108, and they are being creative in sort of making model guidelines to international data transfers under the context of Convention 108. But still, the pace of ratification of Convention 108 Plus, it's very bothersome. It's still it's not yet a mechanism that it's enforced. So my question to the representative of the European Commission, what's the European Commission doing in this regard with regards to making this adequacy decision mechanism much more effective, efficient, and widely, universally available to other countries? Thank you.
Yeah. You can. Now.
Hello, I'm Carolina and I work at JetBrains, and I wanted to ask basically when, for example, checking new vendors or DPAs, what privacy lawyers often do in practice is check if there are SECs in place. And it kind of feels superficial, it feels like a duct tape that once SECs are there, then everything is fine. So can you elaborate a bit on your view on SECs and being used as just something added to the DPAs and all of the sudden all of the transfers are fine? Thank you.
I think now we'll give the floor to the audience, to the panel again. I think there's a lot for Estelle, I'm afraid, for you at least.
Thank you. No, thank you indeed for the questions. I'll first take the points raised by Ralph on the multilateral approach, which will give me, I think, an opportunity to indeed clarify that it's not about negotiating indeed multilateral adequacy decision, if this was the way it was understood. My point was to say that, in fact, indeed, we are seeing convergence in terms of data protection with the fact that more countries are having their system in their laws, which opens to mutual adequacy decision, which of course are bilateral. But also we're seeing bodies like the Council of Europe having standard contractual clause that shares a lot of similarities with ours, and it's about this reflection of would it be a way somehow to bridge our own clauses in Europe with the one of the Council of Europe? But this already You pointed the figure really rightly so, even though those clauses are similar, in Europe we have really clear constitutional or fundamental right level standards on the protection we have. So will be a need to make sure that if and when one day those more multilateral in that sense approach exists, that the level of protection guaranteed in the European Union is not lowered. So this was to reflect the point of the exploratory discussion that there is with tools that bears a lot of similarities and on which there is a fundamental right value as well, like is the case for with the Council of Europe. But indeed to note that this is probably more challenging than one would think to do. But of course, we have the very clear perimeter of the EU for very good reason on the work we do, and this is why the dimension is there. But that doesn't mean that multilateral discussion are not happening, and indeed also cooperation in terms of enforcement of similar challenges that are being faced can exchange. But indeed, we're continuing with adequacy. It's a bilateral discussion for sure, and indeed recalling it's a decision from the Commission that we can indeed at any moment amend, suspend, or repeal. So this is definitely something in our power, and that's why the monitoring happening at the moment is important. There was then a question on the CBPR rules. Actually, thank you for bringing this up, because there is no engagement between the European Commission and CBPR. So if they are, I would be keen to know, because there is not, for the exact reason that you mentioned. CBPR is a model that we are seeing happening. However, the approach that is taken by CBPR, which is in terms of using certification for transfer, is something that is foreseen in our model. And the EU is developing its own certification. And so in terms of model, this is interesting and something to explore. However, the assessment made on the rules under the cross-border privacy rule is that there's too much of a gap with the way the rules exist in Europe. There is a lot of rights lacking, and even when rights exist, they're not clearly enforceable. The oversight and enforcement power around CBPR are also unclear. This is something that was clarified also by some of our data protection authority within the context of G7 to acknowledge those gaps. And so for us, as long as the CBPR system is the way it is right now, there is no opportunity for cooperation because the gaps are too significant. Now we know that there were discussions within this cross-border privacy framework of upgrading the system, and if one day it would be upgraded to a way where there would be that convergence, then why not talk about exchanges? But we are absolutely not there, indeed, because the gaps of understanding of protection is way too big, and in fact is almost even reverse to the one that we have in Europe. So there is no conversation from European Commission with the system.
From the group of national data protection authorities, I remember there's a commission from the CNIL to visit, try and meet them.
All right, then I'll let the CNIL explain. But indeed, from the European Commission, there is no. Okay. We see no viable way with the system in the current form. And just your question on adequacy decision indeed for Latin America, this is a huge priority for the Commission, I can tell you. We are in final phase of negotiation with Brazil, for instance. We are indeed acknowledging that there is a lot that has been done in Latin America in terms of convergence with the EU and with Convention 108 as well in terms of standard. There is also a lot of similarity in judicial system, and so a lot to be built. We're following with a lot of interest what has been happening in Chile, which, as you would know, they do have a law, but they're still building their data protection authority, which obviously would be a necessary component to start any adequacy decision. You've also seen changes happening in Mexico around the authority, actually, and how it may create limitation for exchange. But having said that, we do see Latin America as a huge, it's a very diverse region, but there is one consensus on the fact that it's moving in the same direction and understanding of data protection as the EU, which opens a lot of opportunities. So it's a region for cooperation that on which you will see a lot of more work from the EU. I acknowledge that it's taking time, but it's also to make sure we get things right. But it's an important point. And just to also pass a message on Convention 108+, indeed, more countries are being ratifying, but we also need to do our homework here in Europe. There are still member states from the EU that have not ratified Convention 108, and this is a message that we will continue to pass. All of our EU member states are compliant with Convention 108 by enforcing and applying the GDPR, so please ratify Convention 108+. Thank you.
Thank you very much, Estelle. Indeed, Belgium, which I'm not representing here, I'm here as a moderator, strictly did not ratify Convention 108. Anyone else? I saw you really want to have a question first, but I think we should also give the other panelists a door. But go ahead, go ahead.
Hello, my name is Jan. I used to work for a data protection agency a while ago. Now I consult in the field, and I'd like to see the panel more moving and looking at the elephant, or a certain elephant in the room. It's been mentioned, an orange elephant, maybe you could say. And the question that I have to the panel is, when I consult currently and enterprises ask me to look in their data practices, I do need to make a reassessment in my risk assessment when I see the development in the US. We have a US government that, for a fact, doesn't feel very bound to the rule of law. For a fact, appreciates aggregation of data and processing of data for their political purposes. So when you use services that are from the US, that indicates that you, in your data protection impact assessment, need to make a readjustment given the current circumstances. And I would be very interested in hearing from data protection authorities currently, have they ever heard of Article 36 notifications, if they use the powers under Article 58, if enterprises in Europe are still using Microsoft services, for example, or any other service. And I appreciate Finn, and I tend to agree that we can't shut down everything, but just radically not looking at this is not the right way. We might want to consider successively shutting down these connections. And I think we have to, we're bound by the law. The GDPR prescribes that.
Thank you very much. It's a clear message to data protection authorities, maybe, which I'm not going to answer. I think I will give the panelists the floor.
Yeah.
I think maybe not Estelle to start, but someone else, maybe Jacques, then Finn, and then Theodora.
Yeah, thank you for your question. That's very good. I would like to respond to the first question using the first input we received. I will come back like everything related to surveillance from foreign authority, because that's the issue at stake. If we talk about encryption, it's because that's requests we receive from EU companies who are concerned about surveillance from the US. Of course, that's everything come back to that when you deep into that direction. Now there is other country that comes to mind, but the US is always the first concern they may have, like banks, industry, all these kind of company, they are concerned by the foreign surveillance. So that's why we advocate for encryption. This request from encryption comes from this type of company who are afraid to be subject to surveillance that they can't control. If they don't have the key to encrypt the data, the surveillance authority will not be in capacity to read the data. So that's a measure of protection. If we go, Ralph, into an encryption debate, I won't have the technical knowledge to go really deep into that, but that's my understanding as a lawyer, is that encryption can protect your data. That's the request we heard from big customers who are very concerned about this subject, and that's the way they ask us to respond to, okay, but you're still in the US company, whatever you do, you can have like a lot of presence in Europe, investment and everything, but you're still a US company, you still have interest in the US. And I'm like, yeah, that's true. Well, also you have affiliate in the US, so you will be subject to this surveillance law as well. But we believe we have a solution with encryption in that regard. So that was my first point. And I'm also taking the opportunity to take one of the subjects that was raised by Carolina about the standard contractual clause, that from representing in industry and company in the EU, we see that now there is more and more countries that public their own standard contractual clauses, and that we end up, okay, but I'm a global company, so I need the EU standard contractual clause. But I have interest in Turkey, so I also have the Turkish standard contractual clause. And now we have a pile of requests. So we usually try to explain that the EU standard contractual clause are the most protective tools, so that they could work for other jurisdiction, but as a company representative, I think that would be awesome to have an internal standard on standard contractual clause, like EU and other country can meet and find a way to make that work. That would be amazing. Thank you so much.
Finn.
All right. Okay. Thank you, Ralph. Thank you for your comments, and I completely agree with your assessment, and the also policy making in Brussels better than in this field, better than probably anyone in this room. So when you say what you say, I take definitely note of that. I think the proposal to ban surveillance advertising, as you know, was also a response to a real frustration about the slow enforcement on all these areas. I guess we moved on a bit. There have been some really important court decisions. More are pending. And I completely agree with you. I mean, this is illegal. It is illegal. Yeah. So I think the proposal has been to say it outright because of the enforcement problems we've had. But maybe we should just also be a little patient to get the last few verdicts in that will basically put the nail in the coffin on this business model. I mean, that's what we need to do. So whatever way we get there, I'm open to any suggestions. So completely agree. I also just wanted to note on the issue of digital trade. It's not my expertise. We have a separate committee for that in the TACD. But I got a talking point from my dear colleague, Leah. So I'm not going to pretend to be an expert on this, but it's related, right? And since it was brought up, we see with worry, and this is a worry that we share with other digital rights groups, working on the TACD, US groups, is how trade agreements can be used to undermine these rights. Because a trade agreement cannot be unilaterally revoked. Which in an adequacy decision is then a much better tool from our point of view, instead of putting making basically our data protection and privacy rights into a commodity through a trade agreement. So we'd much rather use adequacy decisions as a tool to ensure these data flows. So that's a point on that. And on the elephant in the room. I completely agree. It's also a bit above my pay grade to say everything on that topic. But let me say on the areas where I see a challenge on the consumer field, I definitely think we see within, for example, EdTech, where basically kids are being made into consumers from the second they use a computer or an iPad or a Chromebook in the school. It's an area where we could do this much faster because these devices are being put out, they're not that advanced, and we could rather quickly kick these actors out of the school and develop software based on our own values. And I think that would send shockwaves through the system and, for example, show the public sector, which is a massive procurer of these services, that this is actually possible. And we can do it in a way that's safe and rather quick. Because I completely agree that we need to take this more seriously. And just as an example, we saw a few weeks ago how a very big company, I don't need to name it, but let's say they provide tech services to schools. They just implemented an app into the ecosystem where they could they got the students report their emotions. And we looked at this and we sort of discussed this, and we realized that this was really hard for us to enforce or to file complaints against, because we could file a complaint to our National Data Protection Agency about this because it was, this company is based in Ireland, surprise, surprise, and we know that would take years. There's no deterrent for this company to change their practices while these schools are being emotionally, sensitive data about them and is being collected randomly without any purpose or any sort of control either from the school. So I think the school system, from my perspective, would have been an easy place to start.
I can take that. Enforcement takes years. Not always. Theodora, you want to add something? And then we have time for a last question or maybe two.
Thank you. So a little remark perhaps on the elephant of the room from a research perspective on my side. So the basic thing I can say, it's a pity what we're seeing, of course. There were already examples way before the current situation of studies being, due to challenges, especially between public authorities, being stopped. There was a big study, observational study between US and Europe, stopped for 18 months, a year and a half. There has been examples of more than 40 clinical trial sites not being able to open in Europe for a big study. And this was before the current challenge. So on my side, unfortunately, I don't have an answer. It's just a big pity for research and for collaboration.
Thank you. I will give, I see a hand there on the back, two hands. Yeah, first you and then Ricardo, I think.
Hi, sorry, Claudia here. My question is for Jack. I'm from the University of Luxembourg, and I obviously agree encryption is better than nothing at all when you're doing transporter flows. But I was a bit taken aback when you said you just do encryption and that's it. Because what about metadata? Metadata cannot be always encrypted. You can do payload packages analysis and actually reveal the information out of it of privacy. So my question is then, how do you deal with the metadata to justify that? Just as like encryption is enough to put safety, or do you use any other mechanisms to do that?
Ricardo.
Hi, my name is Ricardo Catalan. I'm from the Dutch DPA. I cannot say a lot about this because there are other colleagues that do this. This is not my area of expertise, but I want to broaden the scope a little bit because we are very focused on surveillance. Quite recently, we saw how the prosecutor of the ICC in The Hague was locked out of his email box. So it's not just about having access by the administration, also being restricted from your data by the administration. So it's not just about surveillance, it's also the accessibility that should be taken into your assessments. And I think that's a big one. And I just want to make the elephant in the room a little bigger, that's all.
Who wants to react? I think the first question was directed to you, Jacques.
Yeah. So you're right about metadata. The thing is that the transfer of metadata will be, in any case, covered by transfer mechanism. And the fact that the encryption mechanism works or not on metadata, I will be also like redirect the question is like metadata is not the data that foreign public authority will be looking for. They will be looking for information about individuals, not so much about metadata. So the level of protection that we have to apply, we also take the nature of the information, the data itself, into consideration. And yeah, I agree with the second point that was raised. That's very scary. The elephant in the room seems to be under no control, and it's difficult to provide clear response on what's going to happen in the future. I can say that at Salesforce we have great commitment about challenging any request we receive from public authorities. That's part of the agreements we have in place with customers. So we have contractual commitment we have with our EU customers to challenge any request, to inform the customer, and to find a way to fight this kind of event. Oh, well. Okay. Thank you.
Anyone else you want to step in?
Maybe to react just to this last point that was referred to. As you probably all know, it's a little bit outside of data transfer also because we're entering into actually larger territory of, in this case, sanctions and application of sanction. But just to note indeed that there is action being taken in the EU to counter those sanctions and ensure that ICC can function. But indeed, the problematics we are discussing are in some way getting more complicated and more issues are going to be there, and that's also why I think in this changing time, holding back to our principles seems obvious, but it's not necessarily something. It's worth just reminding why we're doing what we're doing and what is our guiding principles to ensure that we have that translated in all our policy actions, basically. And so the responses may need to come from different places, and our issue, as we've all seen in the data protection world, becomes increasingly more than just data protection, but it's always good to actually remember that this is a fundamental right in the EU for very good reason, and this needs to be translated in all our responses.
I think something that would be this is the nice ending or the important ending of this whole conversation. I think stick to our principles when it comes to fundamental rights. That's not so evident anymore these days. If you read the newspapers, even governments now ask to change the European Convention of Human Rights. So it's not just something to say this, but I think that might be a good ending of this discussion. We discussed a lot. Many problems were raised. Very Some solutions came on the table as well, but it's a very complicated area. I want just to thank this nice and distinguished panel, Theodora, Jacques, Estelle, and Finn. Of course, I can talk 1 minute more until the guy comes with the bell, or I can just stop here. I will do the last. I stop.